So good morning and welcome to the University of Chicago Law School, and welcome to the conference celebrating the 50th anniversary of the launch of Richard Epstein's academic career. A 50-year career, and I hasten to add, still going strong. And it's a rare accomplishment to have a 50-year academic career. And I think what's even rarer is that our celebration today is less about the longevity and more about the influence and impact of Richard's career. And as I look around the room, it's incredible to see so many scholars from so many different fields. It's great to see so many former students of Richard's here back at the law school. It's also great to see judges who have cited Richard, influenced by Richard, and have hired Richard's students as clerks. As we look over the program, the range of fields that are covered, from takings and land use, intellectual property, administrative law, corporate law, and of course constitutional law, reflect the range of fields and influence that Richard has had. Indeed, I know that we had a very difficult time in trying to fit all of Richard's scholarship into being represented on the program. And it does not include many of the fields in which Richard has taught, such as criminal law, antitrust, water law, and of course, Roman law. So what accounts for Richard's... It will be there. It will be there. So now, for the rest of us academics who have not achieved the length or influence of Richard's career, this conference provides us an opportunity to look at Richard's career as a role model, and for us to try to figure out what accounts for Richard's enormous influence. Now, our first thought might be Richard's incredible gift for writing and speaking, his endless ability to speak extemporaneously in well-crafted exposition. It's almost Mozartian. As a result, Richard's enormously prolific, of course, in his articles and his books, but also prolific in his op-ed columns, in his blog posts, and nowadays in his tweets. He is a regular presence at conferences, debates, academic events. I hasten to also point out that Richard was a longtime editor of both the Journal of Legal Studies and the Journal of Law and Economics. But I think it goes deeper than that. It's more than that. Richards deploys his skills to address the biggest questions in our legal system and our society. Richard's never been one to write articles that tinker at the margins or make small adjustments to existing law. His work on the common law, often I've read many of his articles, particularly in tort law. They begin by asking questions such as, how should we govern the acquisition of rights in external things? How should those rights be transferred? And how should those rights be protected against intrusion? And right there we have fundamental questions about property law, contract law, tort law. And how has Richard done this? How's he answered these questions? He's developed an intellectual framework and then doggedly worked out its implications. His framework is rooted in a deep regard for individual autonomy, and then he has a deft use of consequential analysis for its practical limitations. And there we see his classical liberalism and his economic analysis. And of course, with that framework in mind, he's not limited himself to private law, but he's proceeded to ask similar questions about public law, hence his far-ranging contributions. Now, Richard is also, using this framework, has often then occupied and taken distinctive positions. For example, while he's deeply associated with law and economics, he disagrees with pure welfarist approaches. His magnificent article, Theory of Strict Liability in the Journal of Legal Studies, is an example of this. His most recent book, Classical Liberal Constitution, challenges both progressive approaches to constitutional interpretation and originalism. So while there are many influences on Richard's thought, his positions are distinctive. Now, he's also intellectually fearless. He doesn't shrink from controversial claims or argue or to shy away from arguing that certain areas of law that most people regard as unshakable bedrock should be dislodged. Think about his position on the Commerce Clause. One particular favorite that I like is the opening of his book, Simple Rules for a Complex World. It begins with the following claim: there's too much law and too many lawyers. Now that's a courageous position to take for someone who's made a living as a law professor. But I think the real secret to Richard's success is his joy in ideas, his infectious enthusiasm for sharing them, for working them out, for challenging them and being challenged, and as a result, his incredible capacity for friendship. And I hope that all of these characteristics we'll see displayed in the conference over the next 2 days. But before we begin, I have a couple of thank yous. So one thank you, a special thank you to Eileen Epstein for her help and guidance on this conference. In the very early stages, we tried to keep it a secret from Richard, but we couldn't. But nevertheless, I'm grateful for her early conspiracy with us. I also want to thank Patrice Scott, who many of you have met, for all of her work in planning in this conference. It wouldn't have been possible without her. I also want to thank Professor Rachel Barco from NYU for all of her help, her insightful thought, and good judgment about so many aspects of this conference. Thank you. I want to thank NYU for collaborating with us. Dean Trevor Morrison will join us tomorrow. I hope that for 2 days, Richard can set aside his usual misgivings about cartelization and allow our two schools to celebrate you together. Richard, congratulations on 50 years in academia. Let's get started on the next 50 years. Congratulations.
Why do you call it right now? It's a joint venture. Yeah, absolutely right. Chicago's moving on. It's had a very bad day.
It is fitting at a conference honoring the career of Richard Epstein, we should begin with a panel that discusses his many contributions to the study of the common law. After all, Professor Epstein first made his mark as a scholar of the common law. My introduction to Professor Epstein came by way of studying his casebook on the law of torts 34 years ago during my first semester of law school in Tulane. And I would dare say that Professor Epstein, a scholar of the common law, shaped his perspective on virtually every other conveners of this conference have assembled a terrific panel to discuss Professor Epstein's scholarship about the common law. Our first panelist is Douglas Baird, the Harry A. Bigelow Distinguished Service Professor of Law here at the University of Chicago Law School, a longtime colleague of Professor Epstein on the Chicago faculty. Professor Baird served as the Dean of the Law School from 1994 to 1999. His research and teaching interests focus on contracts and corporate reorganizations. Professor Baird graduated from Stanford Law School, where he served as the managing editor of the Stanford Law Review. Professor Baird clerked for Judges Shirley Huffstedler and Dorothy Nelson, both on the United States Court of Appeals for the Ninth Circuit, Carlos. And Professor Baird will speak about Epstein on contracts. Now, I learned this morning that this is going to be an even unrulier event than I expected. I told Professor Epstein last night that I thought I had read the papers, the panelists will be fine in the time allotted for them. I'm worried about the responder. And then I learned that the responder wants to speak after each panelist. So my job is even more challenging than I thought it would be this morning. But we'll first hear from Professor Baird.
Thank you. Again, it's a privilege both to be here and also to be the first speaker. I should say that I vividly recall my first meeting with Richard Epstein. It was a wonderful dinner full of conversation. I was a silent spectator, but it was Richard Epstein, Walter Blum, and Frank Easterbrook, and it was just a stunningly impressive intellectual performance by those three, and I was just completely awestruck and silent throughout the entire meal. Now, since it was a job interview of them interviewing me, it wasn't exactly a great start. I think the only thing... The only thing I remember saying is Richard, towards the very end of the dinner, was responding to Frank or Walter with one elegant flourish after another, and downed his glass of wine and continued, and then took my glass of wine and down that. And then I did have the presence of mind to say, Richard, you're drinking my wine. And it was on that basis, I suppose, that he actually wanted to hire me. But I'm forever grateful. And what I've done in this essay is try to pay a homage of sorts to what I take to be the key lessons of Richard's early work. Richard, as you know, studied law at Oxford, read the common law deeply, and his immersion in the common law is one of the defining traits of his scholarship in the 1970s and 80s. Something that's worth emphasizing, and this is why I think looking at contracts is especially useful, is he found a close study of the common law rich and rewarding and insightful, but he didn't take the common law as gospel, and indeed had many critical things to say about it. Starting with one of his early pieces, which is a review of Grant Gilmore's Death of Contract, in which he took Gilmore to task for not getting the history exactly right. What I do in this part of the essay is suggest that you can go to those same materials and look at Gilmore and his account, in particular of Oliver Wendell Holmes and the doctrine of consideration, somewhat differently. So again, Richard had many critical things to say about the common law of contract. Take the doctrine of consideration, please. His critique of Gilmore says that Gilmore, in talking about the evolution of contract law, doesn't really understand what Holmes was doing, and credits Holmes with coming up with a bargain for theory of consideration that Richard says you can find in 16th and 17th century English cases, and that this is a fundamental problem with Gilmore, is that he's giving Holmes too much credit. I suggest, at least in this part of the essay, that's perhaps not the right way, or the only way, or maybe the most trenchant way of looking at what Gilmore did and his account of Holmes. The bigger problem is not so much that Holmes's characterization of the bargain for exchange as being the defining feature of the legally enforceable promise as being new, but rather Holmes's assertion was that it was the only type of legally enforceable promise at common law, and that I suggest is a mistake. The big problem with Holmes was that Holmes had a conception that was too narrow, and it's the narrowness of that conception that introduced problems later on in the 20th century. The reason we have promissory estoppel in large part is because people took Holmes too seriously. An example of this are the charitable subscription cases from the early part of the 19th century. These are all cases in which there's no bargain for exchange, in which courts routinely said consideration existed here. You can read cases like Cardozo's Allegheny College opinion, in which he says, the reason we need to change the common law understanding of consideration is it doesn't take account of these charitable subscription cases. Well, the problem is that Cardozo was starting with Holmes and insisting that the courts that wrestled with these charitable subscription cases somehow had to navigate their way around Holmes. Now, in my space-time continuum, since Holmes wrote after these cases, it's really the other way around. It's a problem with Holmes's account of the common law, not a problem of the common law itself. And the other problem over this domain, and I'm not sure Richard over this part of the essay is going to have much to disagree with, but obviously we'll see, is that in critiquing Holmes and in Holmes himself, one of the things that didn't happen is neither Gilmore nor Holmes took the underlying problem seriously, which is you have to divide the world between those promises that are legally enforceable from those promises that are not. It's one thing to say keeping a promise is a good thing. It's another thing to say a private citizen should be able to call upon the state and use force if necessary in order to ensure that a promise is kept. That's a big deal, and understanding you need to demarcate the realm in which the state will intervene, the state won't intervene, is something we should care about, and something Richard especially should care about. The classic example of this is Hammer versus Sidway. This is the uncle promises his nephew $5,000 if his nephew doesn't eat, drink, gamble or swear or smoke until he's 21. And the question is, does giving up your adolescence, is it worth $5,000? Is this promise legally enforceable? And the answer is we shouldn't shoehorn ourselves into whether or not there's a bargain for exchange. We should look at the more rather fundamental underlying question of whether or not legal enforceability here makes sense. If you look at the backstory of the case, it turns out, quite apart from whether or not the nephew, when he spent 4 years in Ann Arbor, did any drinking, the uncle set him up in business not once but twice. The nephew filed for bankruptcy. The nephew gave a general release to his uncle. It's hard to believe that this promise was still around at the time that the uncle died, and it's also hard to believe that the uncle would want all this in the hands of some judge and a 12-person jury. Anyway, Richard, among other things, worries about legal enforceability, and this is a domain he should care about. Richard, of course, also cares about fraud, and this is the second cautionary lesson I suggest in this essay. Richard, quoting from one of his iconic articles of this period, says, as a moral matter, a person should not profit by his own deceit at the expense of his victim. And it is quite true that a person is in better position to defend himself against fraud than against force, but the carelessness of the victim does not excuse, much less justify, the perpetration of fraud. Richard had this idea that force and fraud are the two defining features of the common law, and at least in this part of the essay, I suggest maybe it's a little bit more complicated than that. Richard suggests at times that figuring out what fraud is really very easy. It turns out it's not easy at all. Again, I look at one of the iconic common law cases. This is Laidlaw versus Oregon. This is where the person buys tobacco at a lot of tobacco because he's learned that the War of 1812 is over, and he learns a few hours before anyone else. And the question is, does he have to disclose to his trading partner that the war is over? And Justice Marshall concludes, no, he does not. And that is supposedly a good thing, and supposedly it's a good thing because as long as he wasn't engaging in fraud, he's entitled to profit off the information he has. I think you need to be careful over both dimensions here. It turns out that the reason Oregon knew that the war was over was that a friend of his was an aide-de-camp to a Navy, the Navy commander during this period. He was sent by Andrew Jackson while New Orleans was under martial law to negotiate with the British, and it was there that he found out about the end of the war. So Oregon was trading on information that he had exclusive rights to by virtue of the fact that New Orleans was under martial law, and a friend of his was one of the few people who was able to leave New Orleans, get information, and come back. Essentially, you can't just say only fraud matters. You can't simply say there shouldn't be any disclosure obligations. All markets are regulated, and you have to worry, especially when the regulator of a market has information, you have to worry about rules of this market. And it's not simply a question of should there be fraud or not. Along another dimension, I would also suggest that fraud is a good place to start, but you can't simply assume that parties want a rule against fraud. Now, no one wants to be defrauded, but that's not the question. The question is whether or not you want to empower judges to decide whether or not there's fraud. That's a harder question. We see environments such as distressed debt trading where people give up that right. People agree that the other person, they're not relying on anything the other person says. Lastly, and I think the issue that Richard will have the most problems with, but I needed to be provocative, given the nature of this kind of conference, is Richard may not take seriously enough in looking at the common law all sorts of limitations that the common law put on the ability of creditors even to collect on a certain debt. There were places where the king's writ could not enter. There was always property that creditors couldn't touch. And when you look at that, you can't simply assume that debts, even if they're legally enforceable, should be enforceable without qualification. So you can keep that in mind and look at Richard's famous essay, justifiably famous essay, on unconscionability, and ask yourself the question when you look at Williams versus Walker Thomas Furniture, whether it's as much of a judicial overreach as Richard suggests. What was at issue in that case was whether or not a creditor could reach exempt property. There's always been, since the earliest days of the common law, limitations on property that creditors could reach. They could not reach the clothes on your back or the tools of your trade. The only reason the cross-collateralization clause matters in Williams versus Walker Thomas Furniture is it affects a waiver of this common law right that had existed for centuries. Waiving that kind of right, allowing creditors to call upon the force of the state in order to reach assets that for hundreds of years the common law has declared off limits, is something you want to worry about, something you want to hesitate about. And at least the suggestion I make is perhaps it's not so odd to say that waivers of that kind of right can't be in fine print and signed by someone who probably doesn't understand them, given that most law professors who teach this case don't understand the point either. But at any rate, the essay, I hope, offers something of a homage to Richard. I've tried to write it in that vein and try to celebrate both Richard and the common law of contracts.
All right, Professor Epstein.
No, I'm going to respond at the end of the three.
Oh, you are?
Yeah.
I was misled.
Oh, you want me to?
No. That's an ancient right at common law. It was not waived. All
I
right.
think it'd be silly to comment after everybody individually.
Good.
Too much meat.
Okay, our second panelist is Thomas Barrow, the Charles Evans Hughes Professor of Law at Columbia. Professor Merrill graduated from here, from the University of Chicago Law School, where he was a student, I believe, and an articles editor of the Chicago Law Review. He's a preeminent scholar of the law of property and a member of the American Academy of Arts and Sciences. He clerked for Judge David Bazelon of the U.S. Court of Appeals for the District of Columbia Circuit, and for Justice Harry Blackmun on the Supreme Court of the United States. He also served as Deputy Solicitor General of the United States. Professor Merrill will speak about Epstein on property.
Thank you, Judge. As the judge mentioned, Richard was my teacher here in my first year at the University of Chicago Law School. He taught contracts at that time rather than property, but he's been very influential in my own thinking over the years, particularly about property. I'm quite attracted to Richard's instinct to look for sort of simple unifying principles as opposed to complexity in the law. And I'm also quite sympathetic to the political vision that Richard has knitted together in his work on classical liberalism. Now, I think the difference between law professors and other types of academics who engage in normative thinking, and Richard is, I think, primarily engaged in normative thinking, is that unlike, say, a political philosopher, I'm thinking now of like Nozick and Rawls, who can sort of spin out an ideal vision of the world based on very thin conceptions of human agency. Law professors are supposed to take into account institutions and institutional constraints that require us to modify our thinking about normative ideals. And Richard, I think, is very much in this vein. I think his effort throughout his life has been to start from a kind of libertarian or corrective justice baseline, but then build into it very important considerations about institutions, and in particular about what the Chicagoans call transaction costs. I understand that term broadly to include administrative costs and things like strategic bargaining, to take those constraints into account and trying to delineate what a legal system ideally should look like. So my task is to talk about how this vision plays out in the world of property law, where Richard has had an enormous influence, I think probably more than any other living academic or maybe even dead academic. My theme throughout here is going to be what I call comparative institutional choice. And the idea I want to try to develop is that Richard takes into account certain institutional constraints on what might otherwise be a kind of autonomy-promoting ideal, but he stops short. He takes into account constraints in the nature of transaction costs to prevent individuals from realizing their objectives because of the collective action difficulties that life presents, but he is not as attentive to the question of what sort of institutions in society we could call upon in order to try to overcome those constraints created by the difficulties of collective action. And so I guess where I would part company with Richard is that I'm even further down the line in the direction of worrying about institutions and constraints than he is, and that pushes me closer to the doctrinal end of scholarship and further away from the pure political philosophy end of things. So in the law of property, in keeping with my theme of institutional choice, I'll start with private law, and then I'll touch on public law. And with respect to private law, I'll start with the legislature rather than the courts. Now, those of you who are familiar with Richard's work on the takings clause and other public law issues might be surprised to know that Richard actually thinks quite highly of certain types of legislation that regulate the relationships between private parties with respect to disputes over their property. Perhaps most striking here is his view of recording acts. These are legislated acts that require or that encourage people to record their property interests, easements, mortgages, and so forth, and thereby reverse the sort of first in time, first in right principle and provide constructive notice to people who might claim to be good faith purchasers who have acquired the property after the initial acquisition takes place. And Richard's enthusiasm for recording acts is quite easily understood. He explains that they make property rights more secure. They operate pretty much autonomously of the need to go to court on a routine basis. And because of the greater certainty that they create, they permit a greater heterogeneity in the way in which people divide up their interests in property, and therefore they promote autonomy with respect to the use of property and permit a greater range of contractual freedom with respect to property rights. Richard is also an enthusiastic supporter of statutes of limitations on efforts to vindicate property rights and the associated doctrine of adverse possession. He starts with a premise that in an ideal world, property rights would be allocated based on first possession, but he readily acknowledges that this should be subject to a legislative constraint that if the first possessor fails to vindicate the property rights and the statute of limitations passes, that the title should pass to a subsequent possessor. And again, the argument in favor of this is that claims of ownership get more costly and are more error-prone as time marches on. Reliance interests accumulate that are contrary to those of the initial possessor. The burden on owners or first possessors is relatively small in terms of vindicating their rights. They just have to monitor and exclude entrants that have no permission. And so these statute of limitations wipe out stale claims, reduce administrative and transaction costs, and increase the value of all property. So Richard says good things about certain types of legislation. When you turn to the courts, interestingly, he also has some rather critical things to say. I know a number of the papers that are going to be presented see Richard as a sort of quintessential common law lawyer, but with respect to property at least, he doesn't seem to be a big fan of the common law of property. His nuisance paper, which I think is critical in his own intellectual development, is quite striking here. Eric and Adam have a paper that they'll present sort of raising questions about Richard's combination of corrective justice and utilitarian constraints, which is what he develops in the nuisance paper. But my focus will be on the sort of idealized doctrine that emerges from that paper. It's a doctrine that is much more constraining of judicial discretion than what we have in the common law, and certainly in what we have in the restatement on nuisance law. He starts with the premise that, the corrective justice premise, that in order to make out a claim for nuisance, you have to show that there's been some invasion of your property, that the boundary has to have been crossed by something. It's not a big boundary crossing like in trespass, but it's a boundary crossing by something like noise or particulate matter or vibrations or things of that nature. And so if there is no boundary crossing, there's no nuisance. And This is justified in part on sort of conceptual grounds that we need to have a baseline understanding of who's entitled to what, but also on the understanding that this promotes autonomy of property owners and sort of libertarian values. You can't sue your neighbor for running around naked in the backyard because that is merely sort of a kind of what he calls a cognitive dislike of what's happening in the neighborhood. And we bar people from suing on reasons like that, and that promotes freedom and autonomy with respect to the use of the property. Having established this baseline, then Richard develops what he calls utilitarian constraints, the live and let live rule and the locality rule. These are kind of reciprocity ideas that if I'm the plaintiff one day and the defendant the next day, it's best just to let things lie rather than subject them to litigation. There's some differences between those principles, and he has other constraints that he adopts. But the thing that interests me is that these are all presented as sort of rule-like exceptions to the rule-like baseline principle of invasion. And so what you get is a doctrine that's much more constraining of judicial discretion than the common law would seem to allow. When you get to restraints on the future use of property here, Richard's hostility to the common law of property comes through loud and clear. Richard's written a couple of articles in which he basically disapproves of practically everything that first-year students struggle with through the property class. Things like the rule against perpetuities, rule against restraints on alienation, the common law doctrine of waste, the idea that there's a touch and concern requirement for covenants to run with the land, the idea that there's a changed circumstances doctrine. Richard disapproves of all this stuff and would basically allow an owner of property to constrain the future use of the property in any way the owner feels is appropriate. And his argument is that there's no real genuine externality here. If an owner wants to put a restraint on alienation on the property in a will where the property is being devised to some kind of family members or something, that's going to diminish the value of the property, and so the owner should internalize that fact in deciding whether or not to restrain alienation. There's no reason for courts to intervene. I think I disagree with this a little bit. I think that most owners, of course, will not want to diminish the value of the property, but there's a few always that make mistakes in this regard. And having some fail-safe doctrines like the rule against restraints and alienation maybe makes sense. The main point I want to make, however, is that Richard, again, is no big fan of the common law of property in this regard, and would like to cut back on doctrines that seem to create a large amount of judicial discretion to interfere with what people do with their property. When we turn to public law, things are a little bit different. Richard's key assumption here, I'm sure other people will talk about this, is what I would call the Lockean Equation. He says that in public law, the state and its state actors, the legislature and so forth, can only do what individuals would want to do or can do in their individual capacity, but are somehow precluded by collective action problems from doing because of transaction costs. So you might think that there'd be a very sort of direct equation between private law and public law, and there is up to a point, but it sort of breaks down. So with respect to the takings doctrine, which is all I have time to talk about, Richard starts out with the assumption that any modification in property values by legislation or by regulatory action requires the state to pay compensation if the value to the owner is diminished in any way whatsoever. The burden is on the state to sort of say why compensation shouldn't be paid, as opposed to the burden on the individual to prove that it should be paid. And there are some defenses. There's the police power defense, which again tracks a sort of vision of the common law of trespass and nuisance. And so there is a direct sort of equation or carryover from private law to public law on the police power end. But then he also advances this sort of general justification of implicit in-kind compensation. And when discussing the private law, implicit in-kind compensation is a sort of justification for some rules, like live and let live and locality rule. When he gets to public law, implicit in-kind compensation becomes a kind of generalized defense, which courts are supposed to use in seeing whether or not compensation is required. And so now we've suddenly given great discretion to judges, as opposed to simply searching out simple mechanical rules that can be applied without significant judicial discretion. The takings clause explication gets into even deeper waters because Richard, the combination of the implicit in-kind compensation rule and the burden shifting and the limited police power, means that any interference with the existing distribution of wealth has to be subject to scrutiny by judges under the takings clause. This is a very big job for judges. They have to look at tax rules. They have to look at any kind of change in liability rules. They have to talk about entitlements programs and whether or not they violate the takings clause, at least in theory. And I suppose if I'm serious about not having any disturbances in the distribution of wealth, we'd have to scrutinize government givings as well as takings, which is hard to fit into the takings clause and so forth. So there are all these problems. The point I would make is that somehow we've shifted from a world in which both the legislature and the courts are subject to sort of simple discretion constraining ideas to one in which now the judiciary is suddenly given enormous discretion to police the political process. And my basic question that I would raise about this is whether, as a matter of comparative institutional choice, this makes sense. Now, I'm not going to argue that the legislature is great and the courts are all bad. I don't think that's the case at all. It's just a matter of which institution, and by legislature I mean both legislation and administrative law, which institution is most likely to get you to something like the classical liberal conception that Richard is aiming for. And I have some worries about the courts. I think, for example, that there's a sort of knowledge problem. How can judges know how to supervise these issues that Richard calls upon them to do? There's a problem with scale. The judiciary, federal judiciary, is a very small institution compared to the political branches. They have to pick and choose what they're going to look at. There's a problem with coordination. You have judges with different ideas. They vote on panels, a majority rule and so forth, and it's hard to see a sort of classical liberal majority emerging anytime soon, and so forth and so on. The legislature is not great. I'll be the first to admit that, but the legislature reflects the America's love of property. The backlash to the Kelo case, I think, demonstrates that Americans love their property, and the legislature will reflect that. Legislatures engage in pluralistic bargaining. And fortunately, in the United States, property law is state law, so you have competition between states, and any state that wants to go crazy on property law is likely to see diminished economic prosperity and economic growth, and that acts as a big constraint on what legislatures do. So that's the end of my time, raising some questions about whether or not Richard's realism about institutions should have gone a bit further than worrying about transaction costs and worrying about institutional choice. Thanks.
Our third panelist is Catherine Sharkey, the Crystal Eastman Professor of Law at the New York University School of Law, a leading authority on the law of torts and federal preemption. Professor Sharkey is co-author with Professor Epstein of Cases and Materials on Torts and co-editor with Saul Levmore of Foundations of Tort Law. Professor Sharkey earned her bachelor's degree in economics summa cum laude from Yale, and this is the most impressive thing to me, where she was captain of and an All-American on the lacrosse team, and her law degree from Yale, where she was an editor of the Yale Law Journal. She clerked for Judge Guido Calabresi on the U.S. Court of Appeals for the Second Circuit and for Justice David Souter on the Supreme Court of the United States. Professor Sharkey will speak about Epstein on the federal preemption of tort law. Yes.
Thank you. It's an honor and a privilege to be here. It was interesting. Douglas talked about the stunning intellectual atmosphere in which he met Richard, and I have a similar story, although I wasn't in the room. So I brazenly sent Richard the first law review article I was trying to write as an aspiring academic, and Richard telephoned me, and I was sitting by myself in an office, and I picked up the phone, and about 20 pages later on a legal steno pad, I wrote down at the bottom of the page, "You're taking us to hell and you don't even have a handbasket." And I thought, well, I'll do well on the market, and I'll do well because I want to be in torts. I had the privilege of studying with Richard's casebook. Never then, for sure, could I have foreseen that I would be here celebrating Richard in this manner, and also as part of a collaboration on this casebook. And I can say that Richard has been the foremost influence on my academic life, starting as a student where I was very excited, having studied economics, to come as a first year and study torts, and then very disappointed that I was given a First Amendment scholar as my professor who had total disdain for the subject, but somehow had used Richard's book. And so that was kind of the start of my intellectual entree. So fast forward to today, I think I learned one lesson in all of this time from that phone call where Richard, in his usual charitable way, actually said, I did have one idea, but it was buried in footnote 232. So on this legal pad, I have hell, no handbasket, and then star, note 232, key. So, but in any event, I also have learned over now more than many, many years, where one of the great things about Richard, of course, is there are no boundaries. So Richard has given me life advice. He's met my entire family. He guides us, and his theories about everything that I should do, not only in terms of what my thinking on torts, but parenting and the like. And it's all very, very appreciated. But I learned another lesson, which is with Richard, from this phone call, I definitely learned, because I was silent. I mean, I was silent, writing furiously. But as I tell some students, you need to interrupt Richard, because he really wants to engage you with your ideas, but you need to interrupt. And the second lesson I learned working on the casebook, I don't know if you remember this, I decided, since I was joining this foremost book, I should start a year ahead of Richard. So I said to Richard, I'll do my edits, etc., and then give it to you a year ahead, and then we can frame the conversation. So for today, given that I wanted to talk about tort, I thought I should insert myself and some ideas. So I've written a lot of papers about federal preemption of tort law, and Richard and I have batted these around over the years. So I figured if I could lay something out before his minutes of remarks, that's a good way to get a conversation with Richard going. And I want to, my paper title is called Field Preemption, Opening the Gates of Escape from Tort Law. And this is a riff on Justice Frankfurter in a dissent in a very prominent preemption decision was worried, called Rice versus Santa Fe Elevator, was reacting against the majority that was going in a pro-preemption direction, and said the gates of escape from, quote, deeply rooted state requirements will be open. And so the premise, there are basically 3 points that I want to make in this paper. And the first is simply, many times I think Richard's views on preemption, because they come up in all these other fields of law, in statutory interpretation, constitutional law, and the like, focus on, and he's written that his view on federal preemption have to do with both his libertarian predilections, right? He has these great statements that are simple and to the point. The FDA device and drug regulation is a system that, quote, cries out for some deregulation. So it seems like preemption, which would be the idea that you would not have two regulators when we're thinking about health and safety and medical devices and drugs. You wouldn't need both the FDA and tort law. So if you have one regulator, instead of ratcheting things up, we should just preempt. And field preemption is a very wide form of preemption, right? It means notwithstanding whether there's any kind of conflict between the state tort law requirement and federal law, you would preempt the field on the theory that the FDA is involved in regulating and passes quite comprehensive regulations about medical devices and drugs. He's also said that his view here is guided by statutory interpretation and the structure of the Food, Drug, and Cosmetic Act and the like. And all of that is true, but I think it misses, the second point I want to make, and I make in this paper, is it misses a big key, which is I think that it's his normative vision of tort law that actually is driving his view of federal preemption. And in some sense, it's not surprising. Everyone who's familiar, for example, with Richard's disdain for the explosion in products liability law, for example, from the 1960s up and through the 1980s, would probably not be surprised that he wishes that many more of these types of products claims remained in the law of contract, not tort. So he's not been He's been quite critical. Furthermore, as an institutional matter, he's very critical about the standards that are used in tort law to decide design defect, this kind of weighing of costs and benefits. And he thinks juries are an abhorrent sort of institution in which to give these kinds of decisions. So given that, interestingly, in some of his thinking about this issue, Richard characteristically inverts the question. Instead of saying, why should we take, deeply rooted state law requirements and displace them? Richard says, why should we not preempt state tort law that is erratic, that is costless, that's hopeless, that doesn't do any good? So he switches the burden in that respect, but it's quite striking because the usual framework would be to think about whether or not the state common law in some sense is at odds with or is not complementary to the federal regulatory system. Richard makes some very good institutional kinds of arguments using, and I think Tom alluded to this as well, his institutional lens is constantly, in every field of law, I think, looking at type 1 versus type 2 errors and trying to use that as a framework for criticizing existing frameworks. So for example, with respect, he uses this to criticize the FDA itself. So he says, for example, that they are overcautious. They're going to tend to be overly stringent in how they're regulating medical devices and drugs because they're too worried about minimizing type 1 errors, which would be the false positives, right? Allowing a drug or a medical device to come to market that ends up hurting someone, but they're missing the fact that type 1 and type 2 errors are typically inversely correlated, and so by minimizing type 1 errors, they're maximizing type 2 errors, which are the false negatives, right? Those are all of the drugs and medical devices that the FDA keeps off the market that could do good. And you can't do a proper cost-benefit analysis unless you're taking both into account. He then further says, though, it's kind of like picking his poison, as between the FDA, which he disdains, in the tort system, it's always going to be focused on the type 1 type errors, and it's going to just get things out of control. So what this does, the second point that I try to expand upon in the paper is it means, I think, that Richard's views, particularly his criticisms of what I'll call more nuanced views, say, like my view on the agency reference model for preemption, are overdetermined, right? So he comes in with this view of field preemption and all of the criticisms of tort law and how it could operate, particularly in the realm of medical devices and drugs. And a model that I had laid out in the past actually calls for courts to use input from the federal regulating agency. And so in a nutshell, for example, in these kinds of cases, you wouldn't always have preemption, but you would have preemption where the FDA had looked at the precise risk that was being regulated. And how would courts know this? They would have to look to the regulatory record. Interestingly, in a very key case in the U.S. Supreme Court, Wyeth versus Levine, which was a case in which the U.S. Supreme Court said that a state law failure to warn claim against a brand name drug manufacturer was not preempted. You could read the majority in the dissent as kind of flailing about because they didn't take an appropriate agency reference perspective in the following sense. The majority says that there can't be preemption here. The FDA gave no more than passing attention to the risks that were involved with this drug that ended up seriously injuring a woman, whereas the dissent, railing against the anti-preemption position of the majority, said there's a 50-year history of back and forth between the FDA looking at the precise risks involved. And my point then and now is that this should have been resolved not by little pieces of the administrative record, but by actually figuring out which side was right on that key core question. Now, Richard has some very powerful, what I'll call internal critiques, right, that are not overdetermined just by his view about getting tort law out of the picture in all of these cases. So he worried about a decade ago that what this would lead to in the courts was basically at the extreme, judges trying to depose FDA officials about what was really going on and the like. And what I try to do in the paper is cautiously nudge him towards looking at the doctrine in the courts that has evolved since Wyeth versus Levine. And I have a lot of examples, actually, where courts seem to be able to use something very akin to an agency reference model in both failure to warn and design defect cases in order to determine if there should or shouldn't be preemption. And so to give just one example, in the drug design context, there's a difference between once a drug has been approved by the FDA if the manufacturer wants to make any kind of modifications. And these can be minor or moderate or major. And if it's a major modification, you actually have to go to the FDA first for pre-approval. And in those kinds of contexts, I argue there should be preemption, and there's no question that the manufacturer couldn't act independently. And by and large, I give some examples in the paper, the courts seem now more inclined to actually look at the actual administrative law record from the FDA in order to make out this question. There's some outliers. There's some courts that don't do that, and I criticize those cases, but my argument would be that it didn't lead to this kind of parade of horribles following something akin to an agency reference approach in preemption. The final and third point that I make in the paper, which to me was new to myself as I was thinking about Richard and his view of tort law kind of being overdetermined of his view against not only the agency reference model, but his whole view of preemption. I started to think back to, in 1998, there's a third restatement of torts, and Henderson and Tversky tried, actually thinking very similarly along the lines of Richard, to rein in tort law. So they came up with a new standard for drug design defect claims. So the idea would be, unlike regular products where you would do a form of a risk utility test, they have in section 6C outlined this test that says that you only should have liability if, when you consider the foreseeable therapeutic benefits compared against the risk, no reasonable physician would prescribe the drug. So many courts thought this was like an immunity provision and not restating the law of torts, and didn't charitably embrace it. But if you go back and think about it, this was articulated in 1998, which was basically right at the moment of the rise of preemption in this area. And the last point that I try to make in the paper is that in some sense, the rise of preemption, not field preemption, but conflict preemption in this area, stunted the potential evolutionary growth of thinking about a different common law standard for governing liability in the drug context. And so there's a certain amount of irony in a sense, right? Because the idea here is that the very articulation of something like field preemption, which never was going to catch on in the courts because it seems so at odds with the doctrinal evolution of the common law of torts, might in some sense have the unfortunate consequence of fueling a situation in which the actual evolutionary growth of that underlying common law standard was stunted. So I think that's interesting. I went back and started to look more carefully at what courts had said about Section 6C, and there are many cases that are more recent cases where the courts don't have any time or space to think about whether that would be a good governing standard because of what's happened with the broadening of preemption. And in some sense, it's a challenge, I think, or that I offer to Richard, to think through whether in a second best world, if we can't have field preemption of the entirety of tort standards in this area, he would be happy with a standard more akin to the narrower standard articulated in the third restatement. Thank you.
Tell me how many minutes, because I am your bound slave.
20.
20? I don't know if I could fill that
She
much
says
time.
10. Her Trace says 10.
She says 10? All right, well, it's going to be, well, I'll be somewhere in the middle. First of all, I'd like to thank all our wonderful panelists for disagreeing with me on so many points. And I also like to thank them, more importantly, for the many, many years of fruitful association that we've had, going back a very long time. I still remember Tom sitting in the back of the room on the right side of this contracts class, puzzling himself over Raffles and Wiggles' house, and I can't tell you the number of interviews and talks that I had with Douglas Baird when he was on the hiring market and I was chairman of the committee. And that epic conversation with Kathy left me completely exhausted when I was sitting in my office at the Center for Advanced Studies, a defect from which I've yet to recover. So let me just make a comment. I won't cover every point that everybody did, and silence should not be regarded as agreement with any criticism. A disagreement is my stock in trade. But let me start with Douglas and the sort of the common law stuff. And Bill Pryor made this gratuitous remark that I was not going to cover anything about Roman law. But of course, that's exactly where the first discussion begins on this thing. The point is about the role of consideration and so forth. We did this in Roman law the other day, right, Mr. Rosansky, if you remember? Yeah, and what happens is that there's a system of law in which consideration is used to demarcate some forms of contracts from others, and you then develop a very systematic body of rules for consideration-like contracts like sale and hire and partnership and certain kinds of agencies, as against other kinds of gratuitous contracts like bailments and loans for consumption and use and so forth. And the rules that you get in these two areas are really quite different. So when you see somebody like Holmes coming up trying to get rid of one half of the entire problem of the gratuitous contract and put all the weight on the other, you just know that he's asking for trouble. It's also the case that, as Douglas said, the older conceptions of what counted as consideration was used in the ordinary English sense of the word, not in the sort of technical sense. In consideration of the fact that you're a charity, I hereby agree to make you this gift. In consideration of marriage, I hereby agree to do this, that, and the other thing. And consideration there was counted as just a good reason for enforcing these kinds of arrangements. And as the English law started to get narrow, you can see the doctrinal stuff breaking down in very many important ways, because the moment you see somebody, quote unquote, trying to find or manufacture consideration, you realize that the doctrine essentially is much too restrictive. And in his written remarks, Douglas says, all the problems it creates, for example, with contract modification and renegotiation under the consideration frame, is now at war with the ordinary commercial situation. So I quite agree with him. The difficulty with Gilmore was not only the ones that Douglas said. This is a wonderful book in terms of its literary quality and its beguiling, but intellectually it was mad. One of his points at the end was laissez-faire means anybody could do whatever they want whenever they want to do so, which is not exactly the way in which Herbert Spencer would have put the point, and it's not exactly the way I would. And he also thought that the separation between contracts and torts was artificial, which is an anathema to a Roman lawyer, where it becomes the fundamental distinction. So we will leave reliance, and then I'll go on to fraud for a second. Douglas is absolutely right, but there's a distinction to be made. There are many easy cases of common law fraud where you just simply have to recite what went on as against what actually happened in the world, and you're stunned about the ability of people to lie with such profusion and enthusiasm that you can't understand how any system of commercial stuff can take place. But with every doctrine, it turns out that not only do you have the easy cases, but you also have the hard cases. So when you're starting to deal with fraud, you have the concealment cases, you have the non-disclosure cases, you have the cases where you have to update previous statements of one kind or another. And those things will all give rise to general difficult questions. But when one wants to think about these kinds of things, the important thing to say about them, I think, is as follows. You never want the hard cases to kill the easy cases. That is, if you get wrong something on the question of whether there's a continuous duty to update under this, that, or the other circumstances, the world will survive if you make that wrong. What it won't survive is if essentially you congratulate fraud in the really blatant and obnoxious fashions. So the key point in the legal system is to make sure that you have the clear areas on both ends rightly decided, and that you understand that the mushy middle will always exist no matter where the doctrines are. One of the reasons why first-year teachers always have an unfair advantage when they do Socratic work is what they can do is they can find a doctrine, and they can always find two cases on the opposite side of that line which are closer together than two cases on the same side of the line. But that's true no matter where you put the line, so it's not a particular argument. What you have to do is to explain why it is, in effect, that one line is better than the other, and as was said earlier by Tom, the point you're trying to do here is not to make marginal adjustments, is to understand fundamental differences in the way in which systems work. When it comes to property law, and what Tom said, I agree with much of what he says and disagree with some of it. Let me start with, I think, the most important point of disagreement, which will, I think, cover all the given areas that you're talking about, which is there are two things in the world that you always have to do in a system of property law. One is to delineate the rights that people have vis-a-vis one another, And in general, when it comes to that particular task, you believe in bright line rules. It's not only just a question of boundaries between neighbors. Try to think of any social organization in which you don't have them. So you have a baseball game and you have fair and foul, the ball is fouled by 1 inch, and the referee says, well, we have to now reconsider whether or not the ball was fouled because of the wind, or whether or not the pitcher threw an exceptionally hard press. No, what you say is the outcome is determined where the boundary is. You don't worry where the inputs go, because you cannot run any kind of sensible system like that. So that's the obvious way in which you start. But there are then two really important complications that have to be taken into account, where you're going to have this kind of discretion whether you like it or not. So I plead guilty to something which I regard as necessary and proper. And the first thing is, sometimes when you have a situation, somebody crosses a line. And then the question is, what's the other guy supposed to do in response? And it turns out you cannot, when you have these kinds of interactive situations, have precision in the responsive situation that you do in the basic eye. You don't know whether you should turn to the left or turn to the right, slow down, speed up, or whatever it is. So immediately when you're dealing with these remedial problems, you have to use such unpleasant words as good faith and reasonable care. And there's simply no way in which you can escape their particular application, but you have to, again, keep it in perspective. Most of the time on a highway, people aren't crossing the lines at the wrong time, and so that the basic rules of traffic allow people to pass very quickly, one to another, without any kind of collisions at all. And you can't say that the system is bad when you get something wrong in these reasonableness type cases where the reaction functions. That's just the way the world is. And the same thing is true with respect to the remedy stuff. Whether you're talking about a private nuisance or you're talking about a public takings case, it's pretty easy in many cases to delineate what the basic rights are in terms of boundary conditions and the crossings that happen. But it becomes much more difficult to figure out what to do under conditions of uncertainty where you're not quite sure what the future level of intensity is going to be or the distribution of various kinds of harms, and you have to try to stop what you're going to figure out to do about them. And so if you start looking at the private law of nuisances, what you discover is that the approach that has always been taken by courts is that you kind of mix and match your remedies. You typically start with injunctive forms of relief, but you realize that if you try to go 100% on that, it's going to become so costly that the whole system will break down. So that what you do in effect is you go 95% of the way there, then you start adding conditions, and then you start adding damages of one form or another, and you do that all the time when you start dealing with ordinary nuisance cases. So it doesn't seem to me that it's a decisive objections against a takings law to say that you're going to have to make exactly the same kinds of actions when the government starts to do things as opposed to private parties. It's the important thing to recognize is that rules get you only so far. They define rights in a very powerful way, but they don't give you remedies when the rights, in fact, are violated. And the theory, of course, of deterrence is you're trying to minimize the violation so that the ordinary rules dominate in virtually all the cases you have. And this also influences the way in which you start thinking about various kinds of property rights systems and so forth. You cannot use a common law system for everything. And so in some of the papers I wrote about, which were not talked about here, which is perfectly fair, you start thinking about the way in which you try to get the complementarities between statutes and common law. I'll just mention two illustrations of the problem. One is you can't run a prior appropriation system in the West unless you have a governor who can tell you when the water is to shut off and when it's turned on. Because these priorities are precise numerical things. Mr. Schwartz in the water law class remembered this a long time ago. And a common law system can only do one of two things. It can either give you a proration rule on the one hand or an absolute priority rule on the other. What it cannot do is measure differences. And so what you do is you find all of these Western guys coming out there, these libertarian types, begging for state intervention. And exactly the same thing happened when you started to talk about oil and gas law, because the common law rules of trespass just did not prevent the dissipation of the fields, and so you get all sorts of unitization rules and the like in order to be able to control that. Now, this constant interaction between common law rules on the one hand and statutory norms on the other also covers many of the things associated with various issues on preemption. And my views on preemption are not quite the way Kathy stated them in this paper. I divide it into two classes. There are those cases in which you have is a situation in which there's a harm inflicted upon a stranger by a defendant who turns out to be in compliance with all applicable statutory norms. And my strict liability hat says in stranger cases, compliance with due care standards does not excuse you, in effect, from harm to others. And that's true whether they're set by statutes or by common law. It's true whether it's in a unitary jurisdiction or it's a federal system where the rules are set by one guy and the tort laws are set by the other. So those cases, I think, it's just fine. But when you're dealing with medicine and various kinds of drugs, the thought that somehow or other, after an explicit warning has been given, everybody has open season to say that it was inadequate. What it does is it creates such an enormous institutional risk that low probability events will nonetheless submarine these kinds of warnings, so that under the current law, when you're dealing with various kinds of warning cases, it may well be the case that virtually no warning will ever get your defendant a summary judgment. And I think it's extremely important when you're thinking about large institutional parties like this to keep the following distinction in mind. If you're dealing with one-off idiosyncratic cases, ex post organization is not that important. But when you're selling millions upon millions of drugs and products and so forth, you really want people to know what the rules of the game are at the time that these particular products are sold. Because otherwise, outrageous things will happen. And in this Wyeth and Levine case, one of the reasons why you want the strong preemption rule is you had this massively incompetent doctor and his nurse injecting blood into arteries instead of into veins, doing so in dosages 10 times the proper level, claiming ignorance, then colluding with the plaintiffs in order to get the drug manufacturer. That's just an unholy kind of mess that can happen. So in those type of situations, you want the rules of the road to be established, and it's not that you don't want tort actions. If it turns out that anybody in one of these cases doesn't comply with the warning standards, then of course you could have a private right of action for breach of statutory duty. But it's one thing to do that, and in this context, quite another thing to do it where in fact there is compliance. So my view about it is that the institutional examination of particular cases is costly. The real danger of the FDA is it's too cautious rather than it's not cautious enough. So I'm just going to give them the benefit of the doubt that they're always doing their science well and too well. And anybody who's watched many of the cases like those involving Duchenne's muscular dystrophy will realize that doctors are screaming to get certain things on the market. Patients will sign anything for treatments that work. And the FDA says, well, this has not been proved to our clinical standards. The real risk there is keeping stuff off the market. A tort remedy won't solve that. And as far as I'm concerned, what we want to do in all of these cases is to try and regularize the situation as with the rules of the road. And then only in those cases where things deviate from the rules of the road for unfashionable situations do we change. So in summing all of this stuff, since Catrice is my taskmaster on this, I think the way in which I would put this is all of these three things face the same kind of problem, which is how it is that you standardize basic transactions for the 95 to 95% of the cases that work well. Constantly try to increase that number. So that when you start to think about law, you think about it more as settling the rules of the road and less about trying to deal with the smash-ups that happen when things get avoided. And so judges, I think, I'm looking at a bunch of them here, have the following real obligation, which is when they decide individual cases, the first thing they have to do is to make sure that in getting the idiosyncratic case correct, they don't manage to mess up all of the things that work well with the system, which never come into the source of litigation. And the danger of using universal reasonableness tests in property, in contract, or in tort is that essentially it can unwire a system which works much better when you understand that there's this appropriate mixture between fixed rules on the one hand and the responses to aberrant cases on the other. May I sit down, Ms. Patrice? Thank you.
Well done. So, you want to respond? Or
No,
you want to take questions? Yes, Mark.
I want to defend Leighton Law of the Oregon and the decision that for quite a number of years I teach this case in my seminar on liberalism. I always interpreted the Leighton Law of the Oregon case as really affirming a kind of general rule that it's okay for people to trade off the ignorance of another party if it has to do with knowledge of market prices. And it's basically the way the market works. I mean, an entrepreneur is an entrepreneur because he understands that something is more valuable than other people think it is, for whatever reasons they have their ignorance. Now, in this particular case, the detail about the negotiations about the end of the war, I mean, the person who was the friend, who was privy to this knowledge, had no fiduciary duty to anybody, certainly not to President Jackson or the military. So I don't see why you were implicitly critical of that case.
Oh, well, yeah, I can. I think I completely agree that for markets to work, it has to be that people who acquire valuable information are able to trade on it. Otherwise, they won't acquire the information in the first place. Okay, and I also want to make the point that anytime you have a market, it's going to be regulated. You'd say, what can be? Take the Chicago Board of Trade. It's the epitome of the free market, but it's one of the most regulated markets in the world. If you want to trade on the Chicago Board of Trade, there are disclosure obligations to the people who run the Board of Trade, not to your trading opposite, but to others. If I am a medieval prince and I want to set up a fair in town, I will have rules of the road and requirements and regulations. And I can almost guarantee you that if I want to create a successful market, one of the things I have to assure the people in the market of is that I'm not going to play games with them. And one of the things we see in late law is we see an environment where we have a market taking place in an environment in which there is market law, and I find it very hard to believe that a sensible legal system in that environment would allow the people who are making the laws to also trade on the basis of information that they uniquely possess.
Yeah, I disagree with that.
Did that meaning with him or with me?
With both of you. What would you expect? In a fest trip, you have the right to be orderly, at least a little bit. But Mario, I think the one point to remember on this particular situation is that the case was one in which it was uncertain as to whether or not the one person had asked the other as to whether or not he knew any information that might influence.
Yeah, there was a remand in the case.
And so the case was remanded. It was not essentially decided that way. And what happens is, and this is one of these fine points in fraud, is if there's a request for information and a non-disclosure, you treat it as the same as fraud. And in many cases, of course, it's exactly what you do. So you can't be evasive about it. The other point is, I think Douglas is wrong. This was not on an exchange. This was essentially two casual people sitting here, there, and the other place. When you're working on an exchange, essentially, whether you're talking about a patent Fran type situation, a stock market exchange, there are rules of the road, but they're not imposed by government. They're imposed essentially by the exchange on this. And though Douglas says he's right about that, but I think it would be very dangerous to try to invent exchange rules for casual interactions, particularly under those circumstances where, if in fact there's uncertainty in the air, this will go on. The other cases that actually raise this, which are equally important, which Douglas didn't talk about, are those cases where there's a modest defect in the condition of the goods, and the buyer says, I'm not going to take them. It has nothing to do with the defect, but it has to do with the radical change in prices that start to happen. And can you get out without a price adjustment on that? That's, again, one of these very hard kinds of marginal cases that everyone's going to have to live with. And it turns out, more than I actually expected, in certainly consumer goods, perfect compliance, not substantial compliance is what is expected. I know this is, although my wife is not here, I've seen what's happened when she goes shopping. I know which rules she trades by. So I think, in effect, that the situation is, in fact, one which falls into the kind of gray areas that I talked about, and that you're going to have to negotiate to some extent on those discussions.
For a necessary follow-up? Go ahead.
That's all right. Go ahead. Are
Well,
you going to follow up on that?
Yeah.
Yeah.
The rules for securities trading are the opposite, Richard. So it was the stricter rules were face-to-face casual exchanges. On exchanges where it was anonymous, the rules were a little more liberal.
No, you're talking about Goodwin and Agassi?
Isn't it
Yeah.
possible?
Well, that's exactly the point. What
Isn't it
happens is
possible
that
there's another way to square the circle, which is that for Doug's concern to be tended to, it is not necessary that we don't enforce the contract. Just like with rejection of the used turkey defense in property, we don't say, look, we care not at all about all of the other people who might have concerns, but we let them show up and voice their concerns by bringing their own action. So, for example, couldn't, in your track pattern, couldn't one or the other of the parties with whom this source of information was consulting state a claim for the profits earned by what you see as ill-gotten contract? I would just, and I think maybe others might just see as gotten contract, and let someone else show up and go after that profit, or not, including, by the way, the government. So in the modern world, what the federal government will do when a defense or intelligence official goes out and writes a book and makes lots of money on state secrets is the government will say, number one, not sure we really like that you did that, but number two, thank you, we'll take your proceeds. But what the government need not do in the contract case, and absent harm to violence type harm, security harm, is simply say, go ahead, you do your deal in the market, but by the way, thank you, you're a good broker, we'll take the proceeds. That's not inconsistent with the concern that you're expressing, but it allows the contract to still stand.
That sounds into the market.
Yeah, again, I'm not, I wouldn't push back against that point. The larger point I'm making, again, pushing back a little bit against what Richard said, is that in the absence of a well-organized market, what we have are the rules that the government sets out. And if the government wants to set out coherent rules, my guess is in almost any system, it won't be a world in which the government will allow one of its own people to engage in trading.
Exactly, and that's the truth with the exchanges. One
Yep.
of the things about exchanges, for example, if you start looking at the securities law, virtually every firm which, for example, a lawyer or financial advisor will have very strict rules against letting any of their employees trade on any information that they receive from the client about some public offering, precisely because what it does is they start to buy, for example, it's going to raise the price which the client has, and that's a handing offense under these circumstances. A casual interaction is either laid low or, in fact, Goodwin Magazine, the case to which Todd is referring to, under those circumstances, it does turn out, in effect, that you don't have these overarching rules. A question that you sometimes have to ask is whether or not non-disclosure in those contexts is tantamount to fraud, where the presumption would be yes, it is. If it turns out it's in response to a question, there's some kind of invasive phenomenon. Next question.
Next question. Yeah, next question.
Come.
Any questions about property or torts?
Somebody.
I have a question for Richard.
All right, there you go.
So I'd be curious to hear Richard's reaction to Tom's claim that you disagree with almost every element of the common law property.
Oh, that's a fair question. No. I mean, there's a little bit of an amiable exaggeration in that. Let's just start with the rule against perpetuities and explain what goes on. At the original time, the basic difficulty that you had with property was as follows. If you have a system in which it turns out that there is no way to put property behind the trust, and what you do is you fragment the land into multiple pieces. What you do by that fragmentation is make it very difficult for third parties to buy, and extremely difficult to figure out who's going to have a remedy in the event that certain kinds of torts take place. And so in the Roman system, for example, what they did is they used the numerous clauses kind of device. You could not have life estates in remainder. You could only have two kinds of estates. You could have a usufruct in possession, or you have what they call the bare proprietorship, so that you can then allocate between the two of you. And the common law, to the extent that it created multiple interests, often was a terrible handicap to various things, and the rule against perpetuities was designed to simplify the tree. The problem is it did it in exactly the wrong way, by using it as a remoteness investing rule, instead of treating it as prevention against the proliferation of multiple successive life estates, all of which would be valid under the rule against perpetuities. The reason that the rule becomes dangerous is after you put property behind the trust, you solve the problem of how it is that you have internal allocations amongst various parties. The trust agreement can do that in incredibly sophisticated ways. But now, since you have a single trustee, the rest of the world essentially can now deal with the owner of the property in a perfectly coherent fashion. So at that point, what you should do about the rule against perpetuities is essentially scrap it, because it becomes, as W. Barton Leach said a long time ago, it became a trap for the unwary. The same thing is true with respect to covenants. It is absolutely clear that it's a great achievement to make sure that when you have transactions that bind the land, successors on both the benefit and the burden side will be there. And these agreements actually do this. But the key case on this is a case called Neponset. I don't know if you remember that from a long time ago. What you did is you had the first plan unit development in a coherent fashion that had been put together by a bunch of people. And there were a bunch of restrictions. You cannot essentially create a covenant engrossed to a stranger. And if you applied it in this particular case, it would mean that the condominium association, which was not an owner of property, could not enforce the arrangements against all of the members, which was bad. Then you start having touch and concern of no value here because these are complete internalized contracts. Every time you apply that requirement, you manage to misunderstand why a particular term was put in there. Nobody has ever written a condominium association deed in which the owner of each apartment is duty-bound to give a haircut to the guy who owns the unit next door. That's what this rule was about. Markets tend to eliminate that. There was another prohibition from the English cases carried over to the American, saying that you can never have affirmative covenants to do things as part of restrictive covenant system. And that makes perfectly good sense if what you're thinking about is having everybody in the condominium association divvying up the chair, so you take out the garbage, I cut the lawn, and so forth. But then what happens is the affirmative obligation was to pay taxes into a fund. And if you can't put that together, the whole system's going to break down. So you have this wonderful opinion by Judge Lehman, in which he takes all the traditional common law requirements, and he kind of cheats on each of them to allow the organization to take place. And once you understand that the consensual model was put together in this case, the last thing you want to do is to have extrinsic rules which limit the freedom of contract in these kinds of comprehensive organizations which have solved the problem of multiple parties in succession by putting together plan unit plans. But in terms of the rest of it, in terms of, nemo dat quo non habet, you can't convey what you don't own, and many of those particular rules. The common law is really quite sophisticated. So it's more selective. The cases that Tom talked about, I think I agree with him on, right? That's what you were thinking about, these two mainly, weren't you? I think so.
I was just responding to your articles in which you said you would get rid of these common law doctrines because the grantor internalizes all the costs.
And that's the restraint on alienation, for example. Generally speaking, if you want to restrain somebody receiving property, if you don't have a return benefit yourself, you're not going to do it. So it's a self-limiting thing. And the argument that I made, and I still stick to it in an article called Why Restrain Alienation, is that generally speaking, government restraints on alienation will be efficient, private restraints on alienation will essentially be sensible. The tricky exception to that is the transferability of water rights. You never allow for the assignment of the rights to water to go independently from the sale of the land because you run the surcharge on the common pool resource, namely the flowing river. So that's just where it is. But you've got to go through these things one at a time. And one of the things you learn about property, I think, after a while, is that the disaggregation, every resource has its own peculiar features. So you have to understand that water is different from oil and gas, is different from the spectrum, different from land, different from chattel, different from animals, different from mineral rights. And you then have to realize that the unifying theme is the constant trade-off when you have multiple parties between situations where there's always externalities on the one hand and always holdout risks on the other, and to figure out which corner you start at and then move to the middle. And the incurable mistake of the Calabrese-Malamed argument, which we've never been able to escape, is they either give you one remedy or the other, damages or injunctions, and every single serious case is always a mix of the two. And so it completely changes the world because the dramatic holdout case doesn't exist if you can back off a little bit. And this is extremely important, right? Scott and Adam, on the eBay injunction type situation, where if you put in a dichotomous, you're going to deny injunction. The correct thing is to grant the injunction and then to postpone its enforcement by 2 weeks or something of the sort in order to make it work.
Just real quickly.
Follow up.
Yeah. I think the first best solution to these problems, I agree with you that the trust is the answer rather than having life estates following life estates and so forth. And the English have done that.
Yeah, 1926 Act.
They have streamlined the law of property to say, well, you can create one life estate or you can have like two people owning as tenants in common. But if you want to do anything more complicated than that, put it in trust. Otherwise, we're not going to recognize it. That's the first best solution. We haven't done that, but you're sort of comparing a situation where we have these messy common law doctrines that sort of clean things up when people make stupid decisions as grantors versus a system where we rely entirely on the internalization of the cost by the grantor. And I think maybe the common law rules, although they're messy, the well-advised people can get around them. The first best solution is clearly to, as you say, use the trust and then have a piece of legislation that says...
And then not to apply the rule against perpetuities to equitable interest behind the trust.
You know, the English still kept the rule against perpetuities, but maybe you could do away with it.
Then they put the life and being stuff and the 40 years wait and see. It became a genuine statutory mess, as opposed to the abolition. That is, because the English rule from 1926, which basically followed practice which had developed in the previous 50 years, was to ban every legal estate except for the fee simple and the lease and the mortgage and essentially the covenants running with the land. So all family estates were put behind the trust. It was an incredibly sophisticated effort, and by and large, they got it right. We have time.
No, we've got about 12 minutes.
Oh, wonderful!
This is why I said earlier he could have 20, but
I'll take the other
he would have taken
I gave it up. Waiver of torts.
So I don't know if this is the occasion to argue each of these points. I found all of that very persuasive, except for the restraints on alienation piece of what you've just said, where it may very well be that in a highly commercial economic context that it's true that people are unlikely to reduce the value of property by attaching weird and stupid restraints on future uses, but property isn't just that. It's, especially when we're thinking about land, there are all kinds of sentimental attachments and I think people, real human beings, real owners of land, often have at least one of two or maybe more sort of non-economically efficient tendencies. One is that they want to rule the future because they want to rule the people who are there. They have a desire to use their control over the land in order to control the people that are going to be there, especially their descendants. And so, attaching restrictions that are going to last forever is this very tempting thing. And the other irrationality is that they may imagine that they're a whole lot better at predicting the future than they really are. And so they think that they're doing something that's sensible and good for the value of the land, but 50 years later, the world is very different, and what they attached, it now makes no sense. And so, at least it seems to me that the common law rule of in which unreasonable restraints on alienation can be challenged has a lot of good sense to it.
Well, there are two situations. I'll give you my answer. One is with respect to family arrangement. I mean, Leach, who was the original expositor of the rule against perpetuities, then turned to be as fierce as the tax, always used to say, and this was my experience when I started out as an estate planner, I don't even know this, Michael, is that you never, any single crazy thing that most people want to do, you could do within the framework of the rule against perpetuities because you treat it as an agent rather than as a restriction. So you manufacture your own life and being, to which you can then add 21 years, and now you control 120 years worth of property devolution of money, and that's 99.9% of the value. Most people don't do that. In fact, the development behind trust is essentially to give the trustees discretion as to particular assets that are kept and traded, to keep most of them liquid, and to essentially try to make sure that you could distribute the net fund, maximizing value out of the thing. In terms of land use restrictions and so forth, yeah, there is something like that occasionally happens, the old Oaks Club and so forth. Most people have now seen exactly what you said, and virtually all the covenants which put restrictions like this You have to use it for an X, Y, and Z. We'll often have governance mechanisms which say, but if 60% of the organization decides that we want to change it, that covenant is no longer going to be in place, precisely because what you said is in fact anticipated by most of the people in question. So I think that you can find imaginary cases, and Tom mentioned several cases, the famous cases of people say, rip down this building when I'm dead, right? And you know, sometimes they actually have real reasons for it. I just don't think you want, well, the abandonment doctrine is a little bit kooky. Restraint on alienation doctrine, as far as I can see, given the sophistication of most people today, does much more mischief than it does good. And you can't get every single case right. And so this is the same thing. Don't give me a single counterexample. I can think of those for every rule. Give me a systematic problem you can have, and I don't think you can find it in this.
Yes.
There's a systematic problem. What about the charitable conservation easement? What's your view on that?
The charitable conservation easement? You know, the same problem, my own view about this is as follows. What you do is, first of all, for those of you who don't know what I was talking about here, somebody wants to basically say, I want to create a greenery and so forth, and I want this thing to exist hell and high water in various kinds of locations. And what they do is they put the property there and they give trustees power of it, and they do this essentially as a, it's not a problem with the rule against perpetuities because the interest vests immediately and it's good for life, right? Right. My view is, you know, it used to be people said, what a waste to put these things in conservation easements. Now people will turn around and say, oh my God, thank God we're putting them into conservation easements because we'll prevent these foul developers from taking over. But you can't protect.
You said that was crazy.
No, it's not crazy. I didn't say that it's crazy. I said, but I think in that case it's perfectly sensible for people to want to do this. But if it turns out that it's too much of a dislocation, the charitable conservation easement is subject to the eminent domain power along with everything else. I actually worked with the Landmark Preservation Council for many years. That may sound odd to you. This was a libertarian organization from Chicago. And what we did when we found properties that we really wanted to preserve, we were quite willing to buy them and to move them to another location if the location wasn't specific to the property. And then sell the plot of land out and use it to fund the change. So you can do these things.
What happened to the public use requirement, Richard?
I mean, what?
If you can condemn conservation easements when it turns out that they're interfering with real estate development.
Well, I mean, look, no, I'm not saying that. The question is, if it turns out what they do is they create some terrible kind of situation and there's a public use, there's no difficulty in the public use requirement. If you say we're taking this conservation easement, that's what we have to do is we have to build a road, for example.
Yeah, right.
So I would apply the same restrictions to conservation easements under Kelo that I apply for anything else. So the pink house is as much protected or as little protected as everything else. And indeed, in the Kelo case, when we argued it, the brief that I wrote, that you guys are condemning property, you don't even know what you want to do with it. The original argument that was made before the Connecticut Supreme Court is just wait, and then take it. And if they had followed that advice, the whole thing would have just simply disappeared. Somebody else?
Yeah. Yes.
Just two comments about Michael's comment. I think the notion that people are attached to their property and therefore may want to do idiosyncratic things with it has significant limitations. And this notion was tested in the housing collapse, right? Because there was an underlying theory that people would be so attached to their properties that they would hold on to them even if housing values continued to drop, and we saw that that wasn't true. So there's a point to which people are willing to do weird things with their property that defy economic logic, and it depends on the circumstances. But market-wide, people are moved by economic incentives when it comes to property, and there's only so much that they're able to and willing to damage the value of their property in the market on a systematic basis. So it doesn't, I don't think, become a systematic problem. Secondly, similarly, these things play out as one-offs, and we shouldn't really worry about one-offs because the results of that one-off experiment get fed back into the market, and they get corrected by the market over time systematically. And so an example of that, in my view, from my own personal experience, is CC&Rs in residential developments. they start off as this notion of a great idea that would improve property values. But, my parents owned a home in a very nice part of Irvine, wonderful schools, next to university. You walk around, everyone says hi to you, lovely place. The properties have not appreciated nearly as much as our neighbors in Brentwood, where anyone can tear anything down and build a mega mansion on what used to be a little bungalow. And the reality is that if you're someone looking to buy property today and you know those facts, then you will not want to be in the CCNR limited area if you're thinking about the potential appreciation of your property. And so, in another sense, if you value some different thing, you might, but overall, people do tend to think about the economic value of the land and where their dollars are going to be in 10 or 20 or 30 years. And so if a mistake gets made in a particular point in time, I think the market just self-corrects, and so we don't really need to worry about issues like that.
I disagree a little bit. It corrects in segments. That is, if you look at co-ops and condominiums, a similar kind of problem. It turns out that people who buy in the CCNR district, those people plan to spend most of their life there, and anybody who's planning to move in 5 years goes somewhere else. And so you can imagine a market in which you have both kinds of an arrangement, and correction is essentially a shift of the relative frequency of one use relative to the other. And what will happen is, over time, you see the condominium form is consistently won out over the co-op form, but all co-ops are not converted to condominium.
We have 2 minutes, basically. Okay.
I just wanted an observation about your response to Kathy in the drug context, and you said, there's these desperate people and they're willing to sign anything. When you say that, I hear freedom of contract, respect people's autonomy, yes, we should let them contract. Of course, everybody else hears, but more than half the world hears, well, that's exactly the problem, people are willing to sign anything. So I just think then it becomes a sort of empirical question that goes to sort of the Basquiat seen, unseen problem. And regulation is like, which of those things is bigger? And how do we, think about the cost on one side versus the cost on the other? So as much as I find that persuasive, I don't think that's persuasive to the end.
Well, can I answer this one?
Yes.
The most important case on this is Abigail Alliance, where there was this drug which might have treated a deadly cancer, which arrived the day after the girl died from Pfizer. They said they wouldn't shift it and so forth. This was not the girl who was making this. She had 15 specialists who had reviewed the entire case, said this experimental drug is better than anything else. And so it's not a question of just desperate uninformed people going to this. If in fact you got rid of the FDA, there's this whole medical establishment out there which helps you in making these kinds of decisions. And I think that using the lateral advantage where people driven out of the country and they go off to the middle of some Mozambique in order to get drugs is not an appropriate thing. Kathy, I don't know, do you agree with that or not? On lateral?
I think that here's the hard case for you that I haven't heard you talk about, is that, the FDA notwithstanding, so there's so many different moving pieces, but the FDA does a certain amount of review, and as you know, even though it's very stringent review, we don't learn information until it goes out into the population. So new risk evidence comes to life post-approval. What should happen? What should happen when the manufacturers haven't given the information back to the drug manufacturer? Should you allow for a tort suit? You say no, and you have overdetermined arguments because you think all of these things belong in the contract. But in the real world, so you're a judge, or you're appointed the restatement fourth of torts, and you have your world where the FDA goes away. What would you articulate as the tort law standard there?
In 30 seconds.
So 30 seconds. I think the important thing to understand is nobody relies on FDA information more than the physician, their test manuals, the drug interaction stuff, the various societies provide much more reliable, consistent information with respect to every subspecialty and so forth. They rely on international rather than local data. And one of the reasons why the FDA is so efficient is if you report an adverse reaction, they're going to treat you like a quasi-criminal. If you go to one of the voluntary organizations, they will say thank you. Guess which gets more information.
Thank everyone.